Hello, hello, hello. Hello, everybody. Welcome in. Welcome in. Welcome. Good to see everybody. My special sub chat Sunday. Hello, welcome, welcome, welcome. We've got a lot of fun stuff to talk about tonight. Yikes. Hello, 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 everybody. Happy sub chat Sunday. Welcome in, welcome. All right, let me see here. I've got to get myself sorted out. Oh my gosh, it's been a day. It's been a day. Oh yes, we've got pictures, everybody. We've got to have some visuals. We got a lot going on. We have a lot. So we do have visuals of our potential witnesses, and then I've got, of course, our counts here, the 34 counts, and then I even have a little bit of evidence, a little bit, not much, but a little bit that we're going to go through tonight. So that should be fun. It should be a full schedule, everybody. Full schedule. Very interesting. Hello, welcome. Welcome in, everybody. Welcome, welcome. Good to see all of you again. Glad we could hop on here. How is the audio? Is the audio okay, everybody? Just needing to double check. Been having some technical problems, so hopefully audio is okay. Hello again. Yes, hello. Good to see you. Okay, it's good. Oh, good, good, good. Thank you so much. Thank you. Appreciate that. Well, hopefully everyone's had a nice Sunday since it's good. It's good. Oh, thank goodness. All right. Everyone's had a nice rest of their Sunday. It's been a busy day around here for me. So I had a family in town, so things got a little bit dicey there for a little bit, but sounds great. Okay, lovely, lovely. Well, welcome to my sub chat, everyone. Now, this is where I have my subscribers only able to chat, but everyone can come and hang out, of course, and also to give my moderators a break. So tonight we are going to be going through, I think this morning was a sub chat. No, Kristen. Oh, Kristen, no. Nope, it was white. It was open for everyone. And then tomorrow, I will be going live every day this week, everyone. I will be doing kind of a Q&A recap of what had happened during the day. So I will be doing that at 7 o'clock Central. I will have my comments open. Hopefully I'll remember to open my comments back up. So, a little dicey. Yeah, well, sometimes with family, you just never know what's going to happen. You just never know. It's like, it could be anything. But tonight, I did want to go through the possible witnesses. Oh, thank you, Kristen. The possible witnesses for the case that's starting tomorrow. Now, I will be kind of doing lots of, even though I'll be doing a recap at 7 o'clock each day of the week, I also will be doing kind of some bonus lives. I'll give about a 2-hour notice window. That'll probably be the best that I can do. But to be able to kind of pop on and give extra information to kind of keep everyone in the loop about what's been going on. So, well, Kristen, excellent point. And I think, and I've planned it out. And I think if I do a Q&A as opposed to actually reading verbatim through a huge document, I think I'll be okay. So it'll be shorter live, so they won't be as long, but I think it should work out okay. So the ability to comment. Hello, welcome, Willie B. Good to see you. Welcome in. I do like to just have my sub chats on Sundays just to give a huge thank you to everyone that is subscribing. That's a very enormous help for my toner fund. I appreciate it so much, and my paper fund. So I'm very thankful for that. Also, it kind of makes our chat a little bit smaller, so it's easier for me to answer questions. Sometimes the chat just goes so fast, I'm not able to get all the questions answered. But tonight, I thought we would go through who I think the witnesses are based off of what I've seen being reported. And so I've had lots of different sources, so I've pulled in my top picks here. Yes, good evening. Good to see you. My top picks. Now, everything that I'm going to talk about with regards to this case, everyone, just so we know, we've got to follow where the facts are coming from, is from the grand jury indictment out of New York. Now, this is available online for anyone. I have gone through it a few times. and I'll continue to go through it because it really is the most accurate information that we have regarding the indictment. So all of this information was presented and given to the grand jury, where they did come back and indict. So we've got that information. I will be double checking, and then I was able to kind of pull a few little extra bits of evidence as well that I thought would be helpful. How am I doing today? Much better. I'm doing much better. My sister came to town, and I adore her with all my heart, but as all of you probably know, I'm about 5 feet tall. I'm short. I'm about Dolly Parton height-wise, and my sister's about 6 feet tall, so she just towers over me, and it doesn't matter how old we get, she will always make some comment that even though she's many, many years younger than me, I'm much shorter. So it's always one of those moments where I have to say, all right. So she is a lovely paralegal, and she lives in a state just north of where I live. So I'm always happy to see her, but it's always a little bit of a, all right, you can go ahead and get in your car and go on now. We've had fun, but bye-bye. So it was great. It was great. They really are. Yes, they really are. They're unpredictable. Indeed. She has a different dad, so that probably explains it too. Her dad's quite a bit taller than my dad. But yes, she pats me on the head, and, that's fine. I'm a grown woman. Oh, my goodness. But I can bite her kneecaps if I need to. But yes, I adore her with all my heart. But sometimes it's a lot. It's a lot. Yes, exactly. Little big sister. Exactly. That's perfect. So, yes, but she is a paralegal, so it absolutely runs in the family. She does a great job with that, so I'm always very proud of her. All right, everyone, 5-2, my daughters. Oh, my gosh, Maura. Oh, I know. I know that's tough. Yeah, when they're that much taller than you, as a tall person, I would never tap someone on the head. Well, it's one of those things, because, I'll go after a kidney. So I kind of have to go for her kidneys, and then she'll tap me on the head. So it's kind of, it's even. we play it out. Always cried for a little brother. Oh, dear. Well, it's the grass is always greener, isn't it? It's always greener on the other side. All right, everyone. So let's go ahead and get started going through these witnesses. And if anyone wants to add information and knowledge that they have, we can certainly add to it as we go through. So next to her, I know. Oh, that's so fun. Yes, tomorrow is the big day. We're very excited about that. We are very, very excited. So it's going to be a great day. We're going to start voir dire tomorrow. So we won't be doing opening statements or anything unless they pick a jury, which I would think would be incredibly weird or unusual if they actually picked a jury tomorrow. So, all right, everyone. So we've got 34 counts. Let's keep that in mind as we go through this. So each count is a writing of some kind. So we have invoices from Michael Cohen. We have entries into a daily general ledger into financial information. We had 2 of those for count 2 and 3. And then we have check stubs. Those are the 3 categories of evidence that we're dealing with. So as we're going through these witnesses, I thought it would be really helpful also to remember that, if we're trying to get, let's say we have this invoice from Michael Cohen. Well, let's just pick a different one that would be a little bit easier. Here we go. Count 12. So we've got a daily general ledger, a writing, and we've got the number for the ledger, and we have the date. Now, if we want to get this writing into court so that the jury can see it, we have to have a mode, which means we have to have a witness. We can't just give it to the jury and say, well, here's this document, take a look at it. We actually have to have a witness. So for any piece of evidence that they are going to be submitting, they're going to have a witness in order to get it in. So the Access Hollywood information, now the judge has ruled the tape can't be played, but that information can all come in. Well, we're going to need a witness for that. So then you have to think, well, who's the witness that's going to be able to get the evidence in? Because you don't have witnesses come in just for fun. You have them come in order to give exhibits to the jury and to give information and evidence. So in this case with the daily general ledger, Now, Mr. Cohen is not the one that was writing this down, so we need the person who wrote in the general ledger as our witness in order to get this writing into the record, in front of our jury. So yes, and authentication is another thing that we have to make sure that it's real. Now, we have a whole set of rules under the rules of evidence called authentication rules, where we're looking for the best evidence rules, we're looking for appropriate writings. So there's all kinds of rules that have to be met in order to even have something come in. Now, you might say, and many might say, well, this is hearsay, because this is something that was made outside of court. You're bringing it in court, and you're bringing to prove it to prove the truth of the matter asserted, being that we've got a fraudulent writing on a business record. And you're right, but this is an exception to the hearsay rules. So many of our pieces of evidence and our exhibits are going to technically be hearsay, but they will qualify under one of the 27 exceptions to hearsay, and that's how we get it in. So as we go through this, we want to think about, well, what evidence is going to be the most important? We're trying to prove here that we've got fraudulent writings, and the purpose was, and what they're trying to prove at that felony level is to prove that it was to interfere with the 2016 election. So many of the pieces they're going to need is going to be that Access Hollywood situation. They're going to want that because the timing is important. What we'll see later is that Ms. Daniels signed her agreement right around the time that whole situation happened. So you can see, well, why did you make this agreement with her, just this short amount of time after the Access Hollywood tape came out? Was it because he felt there would be bad press? That piece is going to be really important. So for every single thing that they need in order to prove their case, their evidence, we're going to have a witness come in order to get it in. So as we go through these 34 counts, again, we have Michael Cohen is going to be able to come in because these are his invoices. So all of the counts that are invoices, Michael Cohen is going to be able to testify to, unless they have someone else who prepared that invoice. If he prepared it himself, he's the best witness to have. But if he's not prepared it, then whoever did prepare it would be the best. So let's just take out of our 34 counts just the invoices. So of course we know Michael Cohen is the former attorney for Mr. Trump, kind of known as the fixer here. So we've got invoices. So we've got counts 1 through 5. Again, I'm just going through here and pulling these. Count 8, count 11, count 14, count 17. I tried to kind of pull these apart earlier. Count 20, count 23 is an invoice, count 26, count 29, and 32. So I think that's all we have for invoices. The rest here are daily ledgers and check stubs. All right, so those are the other two categories that are left. So for these counts, we have 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11. So we have 11 counts, 11 invoices that are Michael Cohen's, which makes sense because it was one for every month, right? So with each one of these, he can testify. Is this the invoice that you created? Yes, it is. And what's on the invoice? And then he can explain it. And then they would say, Your Honor, we would like to admit State's Exhibit 1 into evidence. And then the other side would say, we agree or we disagree. Who knows what's going to happen with the other side. We challenge it, we don't challenge it. And then it'll come in as an exhibit. So that's how that exhibit would come in. So for each one of these invoices, depending on how Judge Mershon wants to run his court, they're going to have to introduce it to Mr. Cohen, and they're going to say, did you create this invoice? Yes. What's the date of the invoice? February 14th. So each invoice is dated a different time. The 16th, April 13th. So they're going to be able to show for each count a different invoice. Now they've got to prove each count beyond a reasonable doubt, so they need Mr. Cohen's testimony to say this is the invoice I created that had the false information on it. Now I did make a note here to just say that the invoices had $35,000 for legal services, request for payment on it. So he sent an invoice out to Mr. Trump saying, I would like to have a repayment for legal fees for $35K. And as we know, this is to pay Mr. Cohen back for the amount that he paid to Ms. Daniels. All right. So we have the invoices here. Those can come in through Mr. Cohen, but we do have the daily ledger writings, and then we also have the check stubs, the check and the check stubs. Now, when we look at the check and the check stubs, I would say that's probably the other category where we can use Mr. Cohen again. So we have, again, these are the counts with just the check stubs. Let me just make sure here. Okay, so we have count 4, count 7, count 13, count 16. Now, each one of these is going to have a different number, so that'll help them to organize it in front of the jury. Count 10, count 19, count 22, count 25, count 28, count 31, and count 34. So each one of these check stubs, then they're going to be able to introduce through Mr. Cohen, but they're going to want to use the check stubs probably through several different witnesses. So I would say, Mr. Cohen, they're going to say, is this a check that you received regarding your legal fees that had to do with actually paying Ms. Daniels? He'll say yes. So what is the check stub number? And he'll say what the number is. What's the date? And they'll say what the date. And they have to do that for each one of the counts. But another thing that they're going to want to do here that I think is really important is they're going to want to distinguish which ones of these were specifically signed by Donald Trump. Not all of them were, but many of them were. So for example, count 31, which was November 21st of 2017, was signed by Donald Trump. All right, so how are we going to get this in? Because Mr. Cohen can say, well, that's his signature, but who knows if Mr. Cohen actually knows what his signature is. They can say, well, you've been his lawyer, you've seen his signature, and those kinds of things, but Mr. Cohen's got some credibility issues, so I would say Mr. Cohen's probably not the best to double check on Mr. Trump's signature. So if it were me, everybody, I would say, let's look through our witnesses and see what other witnesses we could pull in. So Ms. Daniels, she'll come in with the agreement later. Ms. McDougal, she'll come in with the agreement later. Mr. Pecker, he's got his own issues. Mr. Howard, he worked for the Inquirer, he'll come in later. Now, Jeffrey McConney was an ex-controller for the Trump Organization. He was also a defendant in a civil fraud case. So he's a potential for a witness to verify Mr. Trump's signature. So that would be someone that you could put on the stand and say, Mr. McConney, are you familiar with Mr. Trump's signature? Well, yes, I am. And so then you would say for count 31, this is a check. Can you note whose signature is on there? And he would say, well, Mr. Trump. And then you would say, are you familiar with his signature? Are you sure that's his signature as the ex-controller for the Trump Organization? And he would say, yes. But I'm not sure Mr. McConney would be the strongest witness to pull that in. Next, we have the director of the Oval Office and his personal secretary between 2019 and 2017 to 2019. All of these checks were written in 2017, everybody. So I think that's important to note. So we have a signature. We've got trustees here, so that might be better for Mr. McConney. But she would know his signature exactly, Daisy. So I think this Madeline Westerhout, who was his personal secretary and the former director of the Oval Office, would be familiar with Mr. Trump's signature. Now we do, again, I think we only have two. We've got the trustees that signed count 7. Let's just sort it out. And then count 4 was signed by Mr. Weasel and one of Trump's sons. All of the other counts were signed by Mr. Trump. So let's just move count 4 and 7 to the side. So again, we're trying to get these in where these are authentic, these are check stubs. We have to prove each one of these counts beyond a reasonable doubt. Was this check stub done for the reasons that the state put out, and is it authentic? So this one is signed by Mr. Trump. So we're going to take a look, and we're going to, Mr. Weasel, did I mess that up? Oh my gosh. Yes, Weaselman. What's his name? Oh my gosh, I've called him Mr. Weasel so much I don't even remember his name now. I'm so sorry. I'm so sorry. Oh my gosh, what's his name again? Wesselberg. Is it Wesselberg? Wesselberg. I apologize, but only a little bit. All right. Wesselman or Wesselberg? Oh my goodness. All right, so for the counts that we have here, we've got 1, 2, 3, 4. These are checks again. 5, 6, 7, 8, 9. We've got 9 checks signed by Donald Trump. So Miss Westerhout is going to know his signature. She's also going to possibly know if she was there when he signed the check, right? That's going to be another big piece. So she's probably going to be huge when it comes to the checks. So I'm just going to write that down. The checks and the check stubs is going to be a really big part of her testimony in order to get that in. So when we're working on those particular counts, and we have 9 of those exactly, where Mr. Trump signed the checks, she will probably be the person that we got in. We got those counts in through. All right, so we'll keep that in mind. But let's just take a look at the rest of the people here, because we still have 2 check stubs here. 2 trustees signed for count 7, and then we have Wesselman and one of Trump's sons. So we'll probably just use Wesselman for this one. So let's just pull him out too. So she's going to be on the check stubs. And then let's take a look. I think I've got a picture here of Mr. It's Berg. It's Berg. Everybody, I apologize. Wesselberg. All right. So Mr. Wesselberg here signed the check stub for count number 4. All right. So this check for February, he signed it along with one of the Trump sons. So we're going to be able to ask him. So we'll need to ask him about the check regarding count 4. All right. So again, what they're trying to do here is they need to prove all 34 counts beyond a reasonable doubt. So they're going to take it one at a time. You set it up, you knock it down. So first we're going to say, Mr. Cohen, let's go through and talk about these invoices. Next, we're going to say, let's talk about the checks. So for Mr. Wesselberg, they're going to say, hey, did you sign this? Is this your signature on count 4 on this check? And he's going to say, yes, it is. And then they're going to have him, well, why don't you explain to us what this check is then? And then his testimony would come in that way. But that's another way we would corroborate this particular piece of evidence. They won't call him, I don't think. Well, he would just be another one to be able to call in order to testify. Now, I don't know exactly who they're going to pull in. I'm just saying who's going to go along with the evidence. And Trump's son is the other person who signed the check. So if the check has been signed, I highly doubt Mr. Wesselberg and Mr. Trump's son are signing these, but did they actually create the checks? Probably not. So for that situation, we'll get to the Access Hollywood here in a little bit, everybody. But if we're getting into who created it, now we're going to probably get into maybe the executive secretary. So Miss Graff created it. We've got, again, probably the controller, the ex-controller. Maybe he created it. Son would plead the 5th. Well, it's possible. But if he pleads the 5th, what's the jury going to think? If they say, hey, Trump Jr., did you sign this? And he's like, I plead the 5th. Then what's the jury going to say? And that's what it's all about. It's about what he thinks. So the bottom line is we've got probably about 3 or 4 different people in order to get the check stubs in. So we have the invoices now that have been in through Michael Cohen, and he created them. It's possible that if he had a secretary or someone in office actually create the invoice, although for some reason I have this feeling that Mr. Cohen probably made them himself, but those invoices or somebody who received the invoices. So we got the invoices in. Now we've got the check stubs in. All right, Trump, yeah. Now we've got the check stubs in. So that takes us then to the plead the 5th. might think he's being loyal to his dad. Could be. It could be. We don't have that. Now, again, technically, if you plead the fifth in a criminal case, the jury is not supposed to assume that you are guilty. That is not what's supposed to happen. But again, we're humans, so we'll see what does happen. Can be an adverse against them? No, it cannot, Anthony. Great question. And only in civil cases. In criminal cases, that cannot be used against you. The courts have held repeatedly that there should be no inference that if anyone's pleading the fifth, that they did something wrong when it comes to self-incrimination in criminal cases. It's only in our criminal cases, and they do that in order to make sure your constitutional rights not being violated. But not the defendant. I would say that would be across the board. So if you're trying to come in and say, I plead the fifth, then someone comes in later to try to charge you with something saying, well, you pled the fifth, then they're going to come back in and say, well, that's my constitutional right. So what's happening is you can't pull that inference just from testimony in order to come back and have it negatively affect them. It looks bad. Yes. Right. And it's a great question. That's a great question, Anthony, because it just works differently in criminal court than in civil court. And we can, of course, say it, but what actually happens with the jury, we will see what happens. Might not be the case at hand, but another one. Exactly. And so what they don't want you to be able to do is use your testimony in one case against you to bring another case against you later in criminal court. Well, they say Cohen's not reliable because he's a felon. Well, yes. Yes, they will. So let's talk about Mr. Cohen then before we get into the daily ledgers. Just keep in mind, we still have the daily ledgers that we have to get into court. But let's talk about Mr. Cohen. So Mr. Cohen, former lawyer here, he is the one that actually paid Miss Daniels the $130,000. He also has a felony conviction. So he's not exactly what you would call the best witness, but he's needed. He's necessary because we need him, because a whole batch of these counts are his invoices. These are specifically Michael Cohen's invoices. So we need his testimony to be trustworthy enough that the jury believes that the invoices were created the way that he says that they were created. That's it. We don't need them to believe, he's trying to make amends, or that he's trying to, fix everything, or that he's like mea culpa-ing. Like, we don't care. All we need is the jury to believe count number one, invoice for Michael Cohen was created the way and how he said it was done through his testimony. So that's it. Which is a dumb door to open, because why is he a felon? Well, exactly. And they can clean that up. And that's a huge strategy that can be used. So they can say, hey, why should we believe you? Don't you have a felony? And he would say, yes, I do have a felony. And I have a felony because of this kind of stuff that I did for Mr. Trump. So that wouldn't look good for him. But also, even bringing it up is going to be a pain. But also, the state may want to take care of it because he's so well known that they want to take care of it right away and just say, hey, are you telling us the truth today? Well, yes. And how do we know you're telling us the truth today? Because it's well known that you lied to Congress, you lied to judges, you lied to everybody all the time. You're a big liar, lying all the time about everything. Why should we believe you today? So that's kind of one of the issues the state will have to deal with. But again, they also need to really carve it down. So the only thing that we need to believe is exactly what they're putting in front of him. This is the invoice, yes. This was the agreement you had with Miss Daniels, yes. Those kinds of things. Everything else, they can pull in other witnesses and other evidence. But to just keep his testimony very narrow in order to try to say, well, you just have to trust me. Like, well, we don't trust you, Mr. Cohen. I mean, I get it, everybody. I get, I've heard him and I've seen him out there, doing what he's doing, and that's fine. But a jury who's sitting in front of him, I mean, it's up to them. They're going to have to decide whether or not he's believable. And so what the state needs to do is minimize his testimony. His testimony is necessary, but his testimony should not be the number one. He should not be the star witness. He should be a supporting cast member. So he's a supporting cast member to show, here's the invoices. But there are lots of other witnesses in here that should be our star. He will testify. Yeah, I doubt it. I doubt Trump would testify. Would you expect a lot of objections? That's a great question, Cecilia. So when we do objections in criminal court, it means that there's some kind of a violation of the evidentiary rules. So there's a violation for, relevance or hearsay or authentication or, whatever. So it just depends on how they want to do it. I think that objections are more helpful in civil cases to do them more frequently and to get your record built than necessarily in criminal cases, because juries get annoyed with you. I mean, on the one hand, you have to object when you have a legal obligation. As an attorney, you have to object. If there's a problem, you have to object. But if you're just objecting as part of your strategy, that jury's going to be like, dude, we want to go to lunch. Let's wrap it up. If you don't really have a good objection, and if they keep fighting the judge on the objections, juries get frustrated with that too. So I think because we have a jury here, because we are in a criminal case, we're not going to get all of the shenanigans with objections that we normally would see in a civil case. Storms out, the judge will instruct the bailiff to bring him back. I would think so, but I think there would probably be a recess and there would probably be in chambers discussion. I think they're going to have to figure out a way to make it so that it doesn't tarnish the jury. Lunch is always a factor. Absolutely. Absolutely. All right. So Mr. Cohen's got some credibility issues, and I think that's really worth noting right off the bat. So he has credibility problems. And he should not be the star witness, not be the star here. He is important, but he should not be the star of this case. And that's just good strategy overall. How long will the jury selection take? I wouldn't think it would take much more than a week. That's my guess. I would say up to a week. Some people are saying up to 3 weeks. I doubt it. I don't think this judge would push jury selection that long because they're doing so many questions ahead of time. They're doing a lot of work on the front end so that it shouldn't take too long to do that. Who do you think will be the star of the case? I'm not sure yet, everybody. I'm not sure. So let's move past Mr. Cohen. Let's take a look and see. So next we have Miss Clifford, or Miss Stormy Daniels. Now, you might say, well, why is she even involved here? Well, because it was her $130,000 that brought us here. All right, it was her money. This is who was hushed. So we have the National Enquirer involved with this whole situation because they had a heads up because Miss Daniels was like, I've got something to say. And she had something to say right after that Access Hollywood tape dropped. All right. So everybody remembers the Access Hollywood tape, right? Where we all thought, wow, that's really awful. Who would vote for somebody that said something so awful like that? And then, then what happened. So this is the Access Hollywood situation. So this happened. The timing is really important on this because right after this happened, Miss Daniels was like, I got something to say. And AMI went to Mr. Trump and was like, wow, I think we've got an issue here. And so Mr. Cohen was like, yep, we better take care of it. So Avenatti said Stormy asked for the money. So right, now there's a lot of questions going on. And I think this is the best time, everyone, to pause. Let's pause on Miss Daniels here for a minute. Miss Daniels, she's really gotten a bad rap here. And I understand. Some people, for me, if you're doing work, you're working. If you're working hard and you're working, following the law, I don't care what your job is. But some people are kind of judgy about that stuff. But in my opinion, I think Mr. Avenatti was a bit of a bad apple. So she had kind of a bum attorney. And when you get a crap attorney, a lot of bad things can happen, which is really too bad. So another questionable one. Yes. I really liked her. Yes. Well, so let's just take a look quick, everyone. Or however long it takes. So this is all public record. Again, just to remind everyone, friendly reminder, this is all public record. And I just want to make sure, did he get disbarred? Now that I don't know about, but I believe he is in prison still. I believe he is still serving time. Red flag, exactly. Make sure to let me know if I'm out of frame, everyone. So let's take a look here. In March 6th of 2018, we have a defamation lawsuit that was filed by Miss Clifford, or Miss Stormy Daniels, also known as Peggy Peterson, against Mr. Trump and, various other people. Now, some people are going to say, well, this case was dismissed. And that's true. It was dismissed. There was a complaint for declaratory relief. But this case was a bit of an oddball case because what was involved here was a tweet involving her claim that someone had come after her and said, you need to be quiet or you're going to be in danger. So this tweet that said, well, that's bologna sandwich, she said that was defamation. And the court in this situation said, that's rhetorical hyperbole. So you cannot sue for defamation. So the case is dropped. So they dropped the case because of that. They didn't say there wasn't defamation. There was no ruling on whether there was defamation. What there was a ruling on was this tweet and whether or not that could be assessed under the defamation rules. And the judge said no because of the context. All right. So that was very interesting. Unfortunately, Miss Daniels then was required to pay $300,000 to Mr. Trump. She did appeal. She lost her appeal. She tried to get the rate reduced. It was denied again. So there is a hefty amount of money that was involved in this case. Now, she did come back and said, I had told my lawyer, Mr. Avenatti, or whatever his name is, I didn't actually want to file this suit. Again, this suit being that someone had come after her in 2011. That's what this suit's about, all right? 2011, not later. And she had said, I didn't really want Mr. Avenatti to file it, but he filed it anyway. And the judge was like, yeah, that sucks. You still need to pay your $300,000. So, no sympathy. And then Mr. Avenatti's got his own issues. She's got a bum lawyer involved. And there's several bum lawyers involved. But I think it's important to take a look here at her complaint, because her complaint was filed, and this is the factual background that she sets out. So I do want to read through this factual background for a minute, because it's going to give us an idea of what Miss Daniels is going to testify to. So this, I think, is going to be just about, not verbatim, but this is going to be Miss Daniels' testimony. It's just a couple of pages here, and I will need to be careful with my language. But let's go through. So this is the factual background, and then we will go through her NDA, which is also included, as well as the settlement agreement she did with AMI. Again, all public information. So let's take a look. So we have Miss Clifford began an intimate relationship with Mr. Trump in the summer of 2006 in Lake Tahoe and continued her relationship with Mr. Trump well into the year 2007. This relationship included, among other things, at least one, quote, meeting with Mr. Trump in a bungalow at Beverly Hills Hotel located within Los Angeles County. Hello, everybody. Look at this. The very first paragraph. Did we all know this? Did we know? Did we know? Remedy okay, for context, right. Yes, Avenatti. Oh, Avenatti was a problem, definitely. All right, so let's let the bungalow. So I'm going to just keep going here. Here we go. In 2015, Mr. Trump announced his candidacy for President of the United States. On July 19th of 2016, Mr. Trump secured the Republican Party nomination for president. Again, this is a court filing by Ms. Daniels here. On October 7th of 2016, the Washington Post published a video now infamously known as the Access Hollywood tape. That would be this video here, depicting Mr. Trump making lewd remarks about women. In it, Mr. Trump described his attempt to seduce a married woman and how he may start doing things that he and his companion, blah, 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 blah. He then added, quote, some other words that are really awful. Skipping down, everybody. Within days of the publication. So all of this, I just needed to I can't even repeat it, everyone. Within days of the publication of the Access Hollywood tape, several women came forward publicly to tell their personal stories about encounters with Mr. Trump. Around this time, Ms. Clifford likewise sought to share details concerning her relationship and encounters with Mr. Trump with various media outlets. So we had multiple people coming forward with their stories, including Ms. Daniels here. All right. As a result of Ms. Clifford's efforts aimed at publicly disclosing her story and her communications with various media outlets, Ms. Clifford's plans came to the attention of Mr. Trump and his campaign, including Mr. Michael Cohen. Dun dun. An attorney licensed in the state of New York. Mr. Cohen worked as a top attorney at the Trump Organization from 2007 until after the election and presently serves as Mr. Trump's personal attorney. Again, this was filed years ago. He's also generally referred to as Mr. Trump's fixer. All right, so again, we've got this backed up here by this legal filing. After discovering Ms. Clifford's plans, Mr. Trump, with the assistance of his attorney, Mr. Cohen, aggressively sought to silence Ms. Clifford as part of an effort to avoid her telling the truth, thus helping to ensure he won the presidential election. So this could be an important part of her testimony, could be about it being a felony and the interference with the 2016 election. All right, so we've got this whole question of, well, if you put, bad information on business documents, it doesn't make it a felony. No, what makes it a felony is trying to interfere with the election. So Ms. Clifford here is already stating this is what's going on. So this could be part of her testimony. Mr. Cohen subsequently prepared a draft non-disclosure agreement and presented it to Ms. Clifford and her attorney, the Hush Agreement. And I will go through that agreement here in a minute. Ms. Clifford at the time was represented by counsel in California, whose office is located in Beverly Hills, California, within the county of Los Angeles. Again, this is the complaint originally filed. The parties named in the Hush Agreement were Ms. Clifford, Mr. Trump, and Essential Consultants here, and it was formed on October 17th, 2016, just weeks before the 2016 presidential election. So the timing, everyone, of this agreement is really the key. I mean, why do we have this timing? We had it because the tape came out. So the timing is really important. In order to prove that these are at the felony level. On information and belief, EC was created by Mr. Cohen. So again, this is a kind of a shell company we talked about before, and with Mr. Trump's knowledge for one purpose, to hide the true source of funds to be used to pay Ms. Clifford, thus further insulating Mr. Trump from later discovery and scrutiny. By design of Mr. Cohen, the Hush Agreement used aliases to refer to Ms. Clifford and Mr. Trump. Specifically, Ms. Clifford was referred to as alias Peggy Peterson, or PP. Oh my gosh, everybody, I walked into that one. That's uncomfortable. Mr. Trump, on the other hand, was referred to by the alias of David Dennison, or DD. So PP and DD, that's really uncomfortable. Oh my goodness gracious. Attached here too, as Exhibit 1, is a true and current copy of the Hush Agreement, titled Confidential Settlement Agreement and Mutual Release, Assignment of Copyright, Non-Disparagement Agreement. Exhibit 1 is incorporated herein by this reference, and so on. So I do have that agreement attached. Attached here too, as Exhibit 2, is a true and correct copy of the Draft Side Letter Agreement, which was Exhibit A to the Hush Agreement. Exhibit 2 is incorporated as well. Importantly, put yourself in timeout. Oh my goodness. Importantly, the Hush Agreement imposed various conditions and obligations, not only on Ms. Clifford, but also on Mr. Trump. The agreement also required the signature of all parties to the agreement, including that of Mr. Trump. Moreover, as is customary, it was widely understood at all times, that unless all of the parties signed the documents as required, the Hush Agreement, together with all the terms and conditions, was null and void. On or about October 28th of 2016, only days before the election, two of the parties signed the Hush Agreement, Ms. Clifford and Mr. Cohen, on behalf of that shell company he made. Mr. Trump, however, did not sign the agreement, thus rendering it legally null and void of no consequences. Again, this is Ms. Daniels' court filing, so this is her stance on that. On information and belief, despite having detailed knowledge of the Hush Agreement and its terms, including proposed payment of monies to Ms. Clifford and routing those monies through EC, Mr. Trump purposefully did not sign the agreement so he could later, if need be, publicly disavow any knowledge of the Hush Agreement and Ms. Clifford. Now, of course, that has not been proven. That's just a part of this lawsuit here. So flipping over, despite Mr. Trump's failure to sign the hush agreement, Mr. Cohen proceeded to cause $130,000 to be wired to the trust account of Ms. Clifford's attorney. He did so even though there was no legal agreement and thus no written non-disclosure agreement whereby Ms. Clifford was restricted from disclosing the truth about Mr. Trump. Mr. Trump was elected president of the United States on November 8th of 2016. January 2018, certain details of the draft hush agreement emerged in the news media, including, among other things, the existence of the draft agreement, the parties to the draft agreement, and the $130,000 payment provided for under the draft agreement. Also in January 2018, concerned the truth would be disclosed, Mr. Cohen, through intimidation and coercive tactics, forced Ms. Clifford into signing a false statement wherein she stated that reports of her relationship with Mr. Trump were false. Now again, we do not have proof of this. This is her filing this. So we also have public statements. Now, I'm not going to go too much farther here into reading this, but I do want to get kind of this information on where we've got conflicting stories between Cohen and Ms. Daniels, because something here that a lot of people may not realize, you know, Mr. Cohen, we're saying, well, he's a felon and there's going to be issues here. We're going to have some reliability issues. True. We're going to have credibility issues. True. But there's even going to be issues between these two because these two have different stories. And so the state is going to have to figure out a way to make their stories somehow come together without too much of a problem, because he's going to say she isn't right with what she's going to say, and she's going to say that Mr. Cohen was the bad guy here. So that's going to be an issue. If they're having both of these witnesses coming in to testify, they're going to have to figure out how to work that so that their credibility isn't shot. Probationary on paper. Okay, well, that makes sense. All right, so on or about February 13th of 2018, Mr. Cohen issued a public statement regarding Ms. Clifford, the existence of the hush agreement, and details concerning the hush agreement. He did so without any consent by Ms. Clifford, thus evidencing Mr. Cohen's apparent position, at least in that context, that no binding agreement was in place. Among other things, Mr. Cohen said, in a private transaction in 2016, I used my own personal funds to facilitate a payment of $130,000 to Stephanie Clifford. Neither the Trump Organization nor the Trump campaign was a party to the transaction with Ms. Clifford, and neither reimbursed me for the payment, either directly or indirectly. Mr. Cohen concluded his statement with lawyer speak. Just because something isn't true doesn't mean it can't cause you harm or damage. I will always protect Mr. Trump. And that's an end quote. And I have no doubt Mr. Cohen will be cross-examined with that statement. Conflict between the witnesses is not, it most certainly is not bueno. But it's something that can be dealt with and something that I'm sure they've been working on from the beginning. So I don't want to spend too much time further here because, again, this is a lawsuit that was dismissed, but I think we do have some interesting evidence in here to take a look at. We've got Exhibit 1. Again, we're just going through Ms. Daniels here as a witness. So Exhibit number 1. We have a confidential settlement agreement and mutual release, assignment of copyright and non-disparagement agreement. So I have no doubt that this is going to be another piece of evidence, meaning that's another reason why we need Miss Daniels to testify, because she is the one that's going to be able to get this exhibit in front of the jury. So it's going to, the questions will be, well, what is this? Well, this is a settlement agreement, and who signed it? Well, I signed it. And is this a true and accurate representation? Yes, it is. And then they'll say, Your Honor, we'd like to introduce Exhibit 55 into the state's case. And they will say yes or no, depending on the arguments there. So she is needed in order to get this agreement about this amount of money, which is what this whole case is about, right, in front of the jury in order to prove that. So let's take a look here. We have the 28th day of October of 2016, which makes this, again, the date of it very important because of the Access Hollywood tape situation. And then we have ECLLC, which is that shell company that Cohen created, and David Dennison. So David Dennison is Mr. Trump, and Peggy Peterson, which is Miss Daniels or Miss Clifford. So we've got these two people in here, entered into with reference to the facts and circumstances contained to the following. Here, so we've got confidential information involved, and then he's desiring to acquire it. She's saying she's willing to sell it and transfer and turn it over. And then back here, the parties are supposed to be signing it. And I'm trying to look and see where the money was. So transfer of property rights here. Let's see where the money is. Where is the money? Assignment of transfer. Let's see again. Okay, so she has to deliver all. Okay, here it is, right at the top. Sorry, everybody. So, extracurriculars. So here's the settlement terms, all right at the top. So EC, so the shell company created by Mr. Cohen, is to pay $130,000 as follows. So it should be wired to her attorney in a trust account by this period of time. And then we have the bank name and the routing here. And then her attorney shall receive the gross settlement amount in trust. No portion of the settlement amount shall be disbursed by the attorney for her unless and until she executes all required settlement documents. And then they go through further, the legal details of that. So it's $130,000 to her attorney. And then we have further information here just saying again that she the information that she has needs to remain only to Mr. D&D. And then we have signatures here, representatives and warranties regarding prior disclosures, tangible as well. And then we go further through the settlement agreement. So, and representation, warranties, and agreements. So let me ask you this, and this is one thing I think a lot of people kind of forget about when we're putting on a criminal trial. So if we're having Miss Daniels go through this agreement, are we going to want to read this whole agreement out to the jury? How is this going to work? Is our jury going to stay with us while they go into the details for remedies and all the details of disclosures and mutual releases? Are we going to keep the jury's attention during that period of time? Absolutely not. Let me answer that. No, we're not. So we're going to have to figure out a way to summarize and pull out the most important pieces. And that's one of the things that should be done ahead of time, is where they'll talk to opposing counsel and say, hey, these are the pieces that we're planning on using. Are we in agreement? Can we stipulate to that? Can people just pick a fake name to use in a legal document to hide? Well, I think so, as long as everybody knows who it is. People use a lot of aliases. In this kind of an agreement, yeah, I would say so. Because at the end of the day, the most important thing is that she signed it here, right? Or Michael Cohen signed it, and then Keith signed it, and then she signed it. So, we just don't have his signature on it. So we still have appropriate signatures. Oh, no. Oh, Cecilia, be careful. Be careful. All right, so then we have everything signed here as well. So that's the actual agreement that she entered into for the $130,000 through Michael Cohen's shell company. So something I don't have as far as evidence goes are the documents creating that shell company. That's something else that the state has that I have no doubt that they'll talk to Mr. Cohen about. Say, Mr. Cohen, did you create a company in order to give the funds to Miss Daniels? Yes, I did. And how did you do that? 1, 2, 3, 4, 5. And is this the document that created that company? Yes, it is. And is this your signature? Yes, it is. So state would like to offer this, creation of this shell company into evidence. That's how that would go as well. That he didn't sign the agreement. I'm not sure, Donna. I'm not sure. I think that's a good question. And let's ask the chat that. If you're sitting on the jury, now for a minute, let's put aside, our angst for a minute, if possible. And let's say that there's a settlement agreement and a person was paid by the company, but one person involved didn't sign it. Would that matter to you? Would that matter? Would that make or break the deal? You have everybody else's signature, you have the money transferred, you have everyone paid, you have all the other pieces, but one person involved in the situation, the person wanting all of that private information, did not sign it. Would that make a difference? It would matter. It would matter. Okay, no, it wouldn't matter. All right. So that's one of the things to keep in mind too. And I think that's such a great question, because this whole contract is about transfer of property rights to this person. She shall provide to this person counsel copies of this and all of this information. So he's constantly mentioned. So if we take a look at the back, let's see who's actually signed it. He did not sign it. No. She did sign it. Yes. But her attorney signed it and his attorney signed it. So even though he didn't sign it, his attorney signed it. So does that make a difference? That even though it wasn't his own signature, his attorney did sign it? That would be the next question. I don't know. Could the attorney's signature be enough to overcome the fact that he didn't sign it? Yes. Yes, the attorney signed it. Yeah, I think it helps. I think so too. I think it helps also. My attorney can sign for me, right? Your attorney represents you. Yes. No, well, right. You know, and I think that that's something, and that's such a great question. I think that's something else that the state's going to have to address. They're going to have to ask questions like, you know, do you think it's okay for an attorney to sign a contract for you without you having your name on it? Or, you know, that kind of situation, even if you wanted to pull it into voir dire, although their voir dire is going to be plenty big enough anyway. But that could be a question. Does anyone here think that only you can sign a contract? No? Yes? Does anyone here think it's okay if your attorney signs a contract for you? No? Yes? Did anyone here just think that whatever the law says about attorney signing contracts is what you need to follow? Anyone? So we would have those kinds of questions that would have to be sorted out. And this would have to be clarified as well. So there's got to be something in here to clarify who had authority. And so I think they can. Yes. Okay. Well, and it's a great question though, isn't it? You didn't sign it. And then they even gave a reason why they said he didn't sign it so that he didn't have to say. But Mr. Cohen, his attorney, did sign it. So, and on behalf of the company. Great question. And one that the jury will no doubt be thinking about as well. Absolutely. Only if they have a client's permission. Right. It needs to be written up between my attorney and myself first. Fair enough. This is the only thing that always does so they can argue this is what. Right. Many people are saying that as well. They probably have other documents that Mr. Cohen was fine with for the company. Yes, and I have no doubt about that as well. You know, one of the things they could show would be multiple times that Mr. Cohen signed stuff for Mr. Trump. Like, how many times did Mr. Cohen sign his name instead of Mr. Trump signing his name? Because, I mean, you know, he was like the president. So the president's not going to sign all this stuff all the time, right? Mr. Cohen's going to jump in and sign a whole bunch of stuff on the one hand. On the other hand, you know, it's incredibly smart of Mr. Trump to not sign this document that is like not a good document. That was smart of him to do that. But yet they still needed the legal protection, so his attorney took the hit for him. And, you know, Mr. Cohen may have even said to Mr. Trump, don't sign it, I'll sign it for you. Criminally smart. Well, right. I mean, maybe smart's not the right word. I don't think smart and dumb are good words to use during this trial, but, you know, interesting, helpful or not helpful, maybe. Watches The Soprano. Oh my gosh, it's always done this way that it shows a pattern. Yes, exactly, Susan. That's what I think they could show too, is if they had what other NDAs do we have? So, you know, we do have another NDA coming up and we'll take a look at that. So let's go through this real quick. Yeah, exactly. Never admit anything. Well, there's some truth in that. So next we have also a side letter agreement that was included as well. And I think it's worth noting again here that we have the attorney's signatures. We don't have his signatures, but we have the attorney's signatures as well. So we have this agreement. So we've got the $130,000. We need the $130,000 to come in order to figure out why we have all these invoices. Why are we charging count 14? We're doing that because a part of this $130,000 was written up in this invoice. That's why, as legal fees. So that's why we need it. It's not his first rodeo. True story. All right, so that's Miss Daniels. We'll see what happens here. We'll see what happens. I would say overall, she's got some pretty good credibility. There's also some other, bias issues that may need to be taken care of. She's got some issues too between her story and Mr. Cohen's story that they'll need to address as well. But I think it'll be very interesting. All right, so next, who signed the checks? So Mr. Trump signed all the checks, but a couple. I think there are just 2 checks that weren't signed by Mr. Trump. All right, next up, everyone, we have Karen McDougal, and this one gets a little bit wonky here. So she's a Playboy model, alleged now that she had a 9 to 10 month affair with Mr. Trump. We don't know how long exactly, whatever. We have in the indictment, so again, all of the information that I'm bringing out here is all coming from this grand jury indictment. So I'm not just pulling it from CNBC or whatever. Is there a CNBC? I don't know, everyone. I'm trying to think of a media company. I can't even think of one off the top of my head. So she is, so this is from the indictment itself. This is woman 1, all right? So she is, so this next person is woman 1. Here we go. So Karen McDougal. So here's the deal. Karen McDougal was really, her big role is she's part of the Catch and K scheme. So this whole Catch and K scheme, they need to show, because that shows the, illegal piece of it as well, bumping everything up to a felony, right? Because if you're just trying to pay people off to not talk, that's fine. But if you're trying to pay them off so that they don't cause you trouble because you're running for president, that's a different deal. That's a different situation. So let's take a look at some information, some evidence that we have here, because we got to look at the facts, right? We got to find the facts. So we have a lawsuit. That's the best way to look at facts. We have a complaint that she filed against the National Enquirer, all right? Because AMA, the National Enquirer dude, paid her $150,000. Now, she was given $150,000 and also guaranteed to have 2 covers with her name under the byline. So she actually had a couple of deals. She had a couple of deals going on because she's a model. So she's like, put me on the cover of the Enquirer as part of my deal, along with the $150,000, which, by the way, is less than $130,000. I'm just putting that out there. Okay, I'm just putting that out there. So here we go. So this dude, Mr. Pecker, Mr. David Pecker, was in charge of the AMI. All right, he was the eyes and ears, eyes to ears situation of the Catch to whatever scheme. So this fella is the one who paid Miss McDougal here. All right, so he paid her. Now she sued him because she was like, "You didn't put me on the cover." I can't make it up. This actually happened. So this was filed March 20th of 2018. Now, they settled out of court. Here's the settlement agreement right here. They did settle. There was an agreement that was made between them. So there was a settlement done. But I think this is important to know because within the complaint, we have some information that tells us a little bit about what was going on. Because we don't have just Miss Daniels involved in this catch and, dispose of situation. We have 3 people. We have Miss Daniels, Miss McDougal, and then this other Dorman fella. There are 3 dudes, so 3 people. So 2 people were involved with the National Enquirer guy. Okay, he paid them. He actually paid those 2 people. And Miss Daniels was paid by Mr. Cohen directly. All right, so let's take a look. Let's take a little peek at this relationship that Miss McDaniel had with Miss McDougal, that McDougal had with Mr. Trump. Oh my goodness. All right. Let's be careful. I got to be careful again with my language, everyone. I'll read through a little bit here. I know, Dino. Yeah, yeah. I prefer to just call him Mr. Doorman. I feel better about that, just calling him Mr. Doorman. Oh my goodness gracious. Here, in case anyone's wondering, here's the doorman. He's coming up next. All right, here we go. Here's the nature of the case. Oh my goodness gracious. All right, nature of the case. Karen McDougal is a model and actress who first became known for an appearance in Playboy in the late 1990s. After capturing attention of the Playmate as Playmate of the Year in 1998, oh, good for her. Oh, sorry everybody, I'm being tested. I've got to put the puzzle piece in. There we go. Woohoo, I'm verified. All right. Yeah, so I'll be careful here with my language. All right, so good for her. She got Playmate of the Year. She embarked on a successful career as a fitness model. Oh, good for her again. Appearing in and on the cover of numerous, thank you, John, magazines, including the cover of Men's Fitness. That's great. I don't look at Men's Fitness, but I guess apparently a female model on Men's Fitness is appropriate. I don't know these things. For several years, Miss McDougal led a Hollywood life, attending events and parties as both honored guest and hostess. During that time, Miss McDougal had a 10-month relationship with Mr. Trump. Miss McDougal moved on from this period of her life and lived in relative privacy for the next decade. But on May 7th of 2016, 4 days after Mr. Trump became the presumptive Republican presidential nominee, former Playboy Playmate Carrie Stevens revealed the past relationship between Miss McDougal and Mr. Trump on Twitter. Oh, that Twitter. There's just so much trouble. In a series of tweets regarding Mr. Trump's extramarital relationships, Miss Stevens said, and again, I'm being careful here with the language, from what I've heard, you're the easy one. Again, she's upset with Mr. Trump here. And I usually don't get involved in politics, but why Bill Clinton can't get an extramarital thing, but Mr. Trump can. All right, let's take a moment. Yes, someone else told on her. I know, there's so much information, everybody. It's fascinating. All right. Miss McDougal did not seek hush money from Mr. Trump. I think that's important to note. But she also didn't sit back and wait to become tabloid fodder, and I respect that. If the story was going to become national news, she wanted to be the one to tell it, to ensure that the account was accurate and not lurid for the tabloid mill. She hired entertainment lawyer Keith Davidson, who assured her that the rights to publish her story were worth millions. So let's just take a moment. Keith Davidson, this guy that I believe will also be called as a witness, everyone, was her attorney. All right, so let's just keep that in mind. That was her attorney. Unknown to Miss McDougal, Mr. Davidson was working closely with representatives for Mr. Trump while pretending to advocate on her behalf. Mr. Davidson introduced Miss McDougal to AMI, a leading magazine and tabloid publisher. He told her that AMI had deposited $500,000 in an escrow account towards a 7-figure contract that would be presented to her in person in Los Angeles. He later admitted that the $500,000 escrow account was a complete fabrication. So the attorney is bad. Yeah, the attorney we got another bad attorney, everybody. Miss McDougal flew to Los Angeles, where Dylan Howard, a senior executive of AMI, interviewed her for hours about the details of her relationship. So let's hold on here for a second. Okay, just a second. We got to make sure we keep everything straight. This guy, a former editor-in-chief for The Inquirer, all right, he interviewed Miss McDougal regarding her relationship with Mr. Trump. All right, everybody? A lot of bad attorneys here. I agree completely. All right. Later that day, Mr. Davidson informed Miss McDougal that AMI had no interest in purchasing her story. Mr. Davidson failed to mention that after the Los Angeles interview, he and AMI updated Mr. Trump's representatives about Miss McDougal. So this piece is key to show that there was a scheme in place. So there's a scheme going on. There's a scheme. There's criminal activity afoot, everybody. So he's saying, I interviewed her about her relationship, and now he calls Mr. Trump and says, hey, I interviewed this woman about your relationship with her. So Miss McDougal then began discussions with investigative journalists at ABC. After several meetings, ABC made clear that they wanted to do an expose on her relationship with Mr. Trump. This would allow Miss McDougal to tell her story with dignity, which I think is fantastic. After ABC signed a confidentiality agreement, Miss McDougal began to send the network documents. She intended to provide her story to the public on her own terms. Can I just say, I don't even know what I would give for these documents, but it would be something. Like, I would be really interested in these documents. What kind of documents does this woman have? I'm just curious. Shortly thereafter, AMI suddenly reappeared. Again, AMI is the National Enquirer. According to Mr. Davidson, AMI wanted to buy the story of her relationship with Mr. Trump after all. But it would not publish the story because the owner of AMI, David Pecker, is close personal friends with Mr. Trump. In a series of phone calls, Miss McDougal was told by Mr. Davidson that AMI would offer $150,000, 45% of which he would keep. What? Wait a minute. Okay, $150,000, 45% of which he would keep. But Mr. Davidson said that AMI would give Miss Dougal a highly lucrative contract by guaranteeing her 2 magazine covers, including one on Men's Fitness, the cover on which she had made history 17 years earlier. How did she make history? Okay, I'm getting sidetracked. And 24 months of both monthly feature print articles and weekly online columns. So that's a lot. 24 months of monthly feature print articles and weekly online columns. In a hard sell Skype call, Mr. Howard of AMI repeatedly told Miss McDougal how important this part of the deal would be for an old model like her. Oh, that's mean. That's me. AMI and Mr. Davidson failed to tell Miss McDougal that the contract's fine print did not actually obligate AMI to run her columns, the central feature of AMI's promise to create ongoing positive exposure for Miss McDougal. AMI and Mr. Davidson also failed to mention that they were secretly negotiating deals with other women to kill negative stories for Mr. Trump. Whoa! All right, everybody, here's the scheme. That scheme. So Miss McDougal is a key piece of the scheme. So she's going to be testifying about this whole scheme that Mr. Trump set up with this Mr. Pecker fella. So Mr. Pecker and Mr. Trump had this catch scheme, and she's going to be testifying about it because she sued them because they didn't fulfill their obligations. So, yikes. All right, let's keep going here. Miss McDougal was pressured by AMI and her own lawyer into signing. So let's just double check. Let's make sure we're keeping all of the information straight. This was her lawyer here, this fella, into signing the contract within hours of receiving it, even though she had made clear in emails and on that Skype that she could not make sense of important aspects of the contract. She relied entirely on AMI and Mr. Davidson's promises about what the contract said and meant. Oh dear. Oh, we hate to hear that. Oh, we hate to hear it. And her first inkling that she'd been duped came days before the election day in 2016, after months of radio silence from AMI about her weekly columns, when the Wall Street Journal wrote a story about her in the AMI contract. Days later, Miss McDougal fired Mr. Davidson and secured pro bono help from renowned First Amendment lawyer Ted Botris and his law firm. Oh, good for her. All right, so she fired the attorney. Good for her. By the end of November of 2016, AMI agreed to an amendment which clarified that Ms. McDougal could respond to legitimate press inquiries about her past relationship with Mr. Trump. But that turned out to be part of another tactic to suppress Ms. McDougal's story. AMI offered to pay for a top PR team to assist Ms. McDougal for 6 months in responding to press inquiries. In the year plus that followed, however, AMI was told Ms. McDougal to say nothing about the relationship to reporters that contact her, and instead to forward misleading emails to AMI ghostwriters. AMI has simultaneously provided those same reporters false and misleading information, both on the record and on background. And each time that Ms. McDougal has taken steps to set the record straight, AMI has responded with threats and intimidation. Oh, I know, Tay. This is awful. This is really awful. You know, I really didn't realize how hard this really hit this poor woman. But this sounds pretty awful. Weeks ago, the New York Times reported that AMI and Mr. Davidson had coordinated with representatives for Mr. Trump in the summer of 2016 about Ms. McDougal's deal. So I think the timing of this is important too, everyone, because this goes to show that the scheme was intact. So we've got this whole situation with Miss Daniels because of the Access Hollywood situation. But this situation was in the summer of 2016. So this had been going on for a while with Mr. Pecker. Who was he married to when this affair happened? That's a good question. I don't know. It was in the 90s. So, I mean, he was with Ivanka, and then he was with Marla, but I don't know when they got married. He doesn't even know when they got married. Does anyone remember that in his deposition? They asked, like, well, when did you get married? And he's like, I don't know, in the 90s. I was like, oh my goodness. All right. So summer of 2016. So I think this is another really important point that the DA can bring out about the scheme that they had together. Ivana, not Ivanka. Sorry about that. Apologize. Oh my gosh. All right. So neither AMI nor Mr. Davidson told Ms. McDougal about these communications, nor did AMI make required disclosures under the campaign finance laws. This is another huge piece of it, according to recent complaints filed with the FEC and the Department of Justice. As a result, Ms. McDougal finds herself at the center of a national controversy about a major threat to the democratic process. She is the subject of an FEC and DOJ complaints against AMI and the Trump campaign. Again, this was filed in 2018, everybody, and her pro bono litigation team has just received a document preservation demand from BuzzFeed lawyers defending a defamation suit by Michael Cohen. Oh dear. Trump's fixer over a column about his alleged collusion with Russia. Nevertheless, AMI continues to intimidate Ms. McDougal with legal and financial threats if she speaks with the press. Ms. McDougal brings this lawsuit seeking judicial declaration that her agreement with AMI is void due to both fraud and illegality. The agreement is contrary to basic principles of law, fairness, and the public interest. This court should not sanction AMI's effort to use it to intimidate Ms. McDougal and deceive the American public. I know. Oh my gosh, it's a lot. All right, so let's just flip through this here. So factual allegations. And again, this is all available online. It's available to anybody that would like to pull it up. We have a tweet here saying, all true. I was friends with her during the time of the affair. She told me about it in detail, but I'm sure no one's shocked that he's not faithful. It's the cover-up and payoffs that should signal an alarm to the bigger picture, which is the point here. All right. Yikes. This is crazy. It is crazy, Suze. I just want to hit the headlines here, the high points. Ms. McDougal hires Keith Davidson as her attorney and begins discussions with two publishers, American Media and ABC. And then we'll just flip to the next one. On August 5th of 2016, Mr. Davidson and AMI tricked Ms. McDougal into immediately signing a contract she did not understand. That's awful. And then we have here, Mr. Howard's messages are in gray. So we have a text message. Confusion and concern about the health and fitness exposure she would obtain from the contract. rather than walk her through the details. She texted Mr. Howard of AMI and then forwarded his response. So here we go. Busy, Karen leaves at 5:30 a.m. tomorrow. She wants to know if she can pick her own hair and makeup for shoots, and if AMI covers costs of travel for cover shoots. Let me know if you can, so I can try to have her sign it before she leaves. Of course, we provide it all, coverage and the best snappers. What? Thanks. Tell her it's fine. I've got her covered on everything. Seriously, she will be looked after in the most emphatic fashion. Great, thanks. I'll let her know. So we've got a text. Showing that kind of false, misleading information again, because I don't think they're going to cover her stuff. Contrary to its representations, AMI displays its total lack of interest in Miss McDougal's career. I think that was pretty obvious as well. And so we've got another tweet by this attorney saying he will represent her. So I repeat, I will represent pro bono anyone that Trump sues for exercising their free speech rights. Many other lawyers have offered to join me. Oh, that's good for him. All right, so she is able to get pro bono assistance. Next, AMI refuses to honor the amendment and uses the PR firm to further silence Ms. McDougal. Here we go. And then we've got kind of this back and forth, so I'm not going to spend too much time on that. We're kind of fast forwarding. AMI continues to employ a carrot and stick methodology to keep Ms. McDougal silent. Oh my goodness. Oh, this company. This is awful. And attorney. Yikes. All right. The New York Times exposes direct coordination between Mr. Davidson, AMI, and Mr. Cohen. And Ms. McDougal becomes the subject of the FEC and DOJ complaints and a litigation hold in a defamation suit regarding the Russian collusion. Oh my gosh. Yikes. All right, so, all right, New York Times reveals that. Oh my goodness. All right, first cause of action. And so then she comes in and pleads out her causes of action. So this again is a complaint that she filed her lawsuit against them. Let's fast forward a little bit here so that I can show you American media. Again, American media is this Mr. Pecker fella, and he is the AMI person. And so they put together this agreement. So she had an agreement for magazine covers, to pose for and appear on the cover of Men's Fitness and Muscle and Fitness, hers, to be interviewed for articles and so on. She was to be paid $150,000 as part of that agreement. Let's see. Deemed work for hire, personal, unique in nature, may not assign this agreement or any obligations here. So this is the, you're supposed to have a certain number of columns, you're supposed to have a certain amount of money, and then we signed it. So she signed it here, and then he signed it over here. So that was their agreement. Oh my gosh. Oh, it's so awful. And then we have an amendment here. McDougal agrees that McDougal shall not grant the same or similar rights to any other party that McDougal has granted to AMI pursuant to this agreement with prior written approval of AMI. In addition, she shall not disclose, write about, nor cause to be disclosed or written about, including any posts on social media such as Facebook, Twitter, etc., nor give interviews relating to McDougal's limited life story rights granted herein at any time without prior written consent of AMI, except as required by law. McDougal acknowledges and agrees that in the event McDougal violates the terms of this paragraph, AMI will suffer damages and other harm that will be significant but difficult to measure. Therefore, in addition to its other remedies in law or equity, AMI shall be entitled to liquidated damages in the amount of $150,000 for any such breach. Notwithstanding the above, McDougal may respond to legitimate press inquiries regarding the facts of her alleged relationship with Donald Trump. In connection therewith, AMI shall retain the services of these people for a period of 1 month commencing December 1st of 2016. Wow. Oh my gosh, I feel so bad. Oh, I know. Oh my gosh. All right, and then Exhibit C just kind of goes through, just walks through more of what she was supposed to have been given. You know, I mean, she was trying to go forward with her career. She was trying to go forward with her career. She wasn't here for the hush money. She was saying, I've got a story to tell. And they were saying, sure, we'll set you up and help you go forward with your career. And they did not. So that's further on that. She was really, good question. All right, so here we go, everyone. Again, this was settled. This was a lawsuit that was settled. Let's take a look and see. Let me see. I'm just trying to scan real quick through here. What did we agree on? Five columns. Okay, so 5 columns is agreed to, how the right and obligation to do a cover. So it looks like they came to an agreement that involved her getting her columns and getting her covers. So $75,000 in royalties and so on. But this was the agreement that was reached in November of 2016 is when she signed it. And this was filed in March of 2018. Wait, that's not right. Sorry, everybody. This was attached exhibit. Wrong page. Here we go. The year was off. Like, that doesn't look right. Okay, so this was April. This agreement was April of 2018, and this was filed in March of 2018. So we do have an agreement set out. All right, so that's the long and short of it for Miss McDougal. Okay, so that's Miss McDougal's story, everyone. Oh my goodness. All right. Okay, I've got just enough time left, everyone, to do the limo, or not the limo. Sorry, that was a different case. Whoops. I've got enough time to do the doorman. So let's talk about the doorman tonight, and then I'll have to hit the rest of the witnesses. This will be to be continued, everyone. To be continued. All right, so let's talk here. We've got one more, the third in the trilogy, the third hushed. Again, all of this information is coming directly from the indictment. So this isn't just for funsies. This is from the Chapter 5, the doorman. I know. All right, so let's take a look here real quick. So for those of you who may not remember, there was a doorman. And that's this person here, Mr. Dino. All right, let's just read what was in the indictment regarding the doorman. Suppressing the doorman story. So again, this is part of that catch and get rid of it scheme with Mr. Trump and the National Enquirer. So here we go. A few months later, in or on October or November of 2015, the AMI CEO learned that a former Trump Tower doorman, also known as the doorman, was trying to sell information regarding a child that the defendant had allegedly fathered out of wedlock. At the AMI CEO's direction, AMI negotiated and signed an agreement to pay the doorman $30,000 to acquire exclusive rights to the story. Oops, let me bump this up a little bit, everyone. I apologize. AMI falsely characterized this payment in AMI's books and on the records, including in his general ledger. AMI purchased the information from the doorman without fully investigating his claims. But the AMI CEO directed that the deal take place because of his agreement with the defendant, so Mr. Trump, and lawyer A, which is Mr. Cohen. When the AMI later concluded the story was not true, the AMI CEO wanted to release the doorman from the agreement. However, Mr. Cohen instructed the AMI fella not to release the doorman until after the presidential election, and the AMI CEO complied with that instruction because of his agreement with Mr. Trump and Mr. Cohen. So again, the timing is incredibly important here. All right, so here's Mr. Mr. Dino here. Now, Mr. Dino signed this agreement for the hush money and was paid $30,000. So I happen to have, okay, so you can see here there's an agreement, and I have it here. This was an amendment that he signed, so in December 15th, but this was the original AMI agreement. So again, keep in mind, this agreement was done with this guy who's like making all of these agreements with Mr. Trump about like not any of his information getting out there. So let's see if we can read this. Let's see if we can read it. Okay. So payment $30,000 payable upon publication as set forth below. Exclusive. Source shall provide AMI with information regarding Donald Trump's illegitimate child and any and all documentation, including but not limited to letters and any legal documents and photographs in the source's possession relevant to the exclusive, sorry everybody, I can't quite see that, exclusive agreements. I don't know, this one's a bit smudgy here. It gets a bit smudgy. And then publishing articles, and this was signed, so it looks like he changed the agreement here and then signed it. Well, I don't know if there's a mini, oh my gosh. Yeah, I'm not sure. Now, again, in the indictment, it says that AMI discovered that this wasn't true. All right, so according to the indictment, that's what it's saying here. But, you know, too cheap to have a good print. I know, this was... Now, my printer is exceptional, everyone, but this was what was available online. You know, it's not particularly easy to find all this stuff. Oh, I laugh. Okay, here we go. This agreement is entered into by and between the source media here. They're granting worldwide rights to AMI for publication of the exclusive, and the source therefore agrees to the following. And then this is just the regular fact that whatever the source is with the story can't divulge that information. I know. Oh my gosh. All right, so here's the amendment. So the reason, again, I bring this up is because that's what's in this picture here. So here's Mr. Dino, here's Mr. Trump, here's their agreement. Oh my gosh. References made to the source agreement dated November 15th of 2015 by and between Dino Sajidin, the source, and the American Media Company, AMI. Capitalized terms not otherwise defined herein shall have the meaning set forth in such agreement. For good and valuable consideration, receipt on which is hereby acknowledged, source and AMI have agreed and do by hereby agree that the agreement is hereby amended as follows. So here's the amendment. AMI shall pay the source the payment set forth in the agreement of $30,000 within 5 days of receipt of the amendment signed by source. The exclusionary period set forth in the agreement is extended to in perpetuity and shall not expire. I'm not sure that's legal. I think we might have some legal language. $30K on toner and paper. I laugh because it's kind of true. The source agrees that he shall not disclose the exclusive or the terms of the agreement or this amendment to any third party except as required by law or court order, or somehow it gets online and then a curious attorney just pulls it up and prints it out. Provided source gives AMI prompt written notice of such requirement or order, so AMI may seek an appropriate protective order or other relief in the event the source breaches this provision. Source shall be liable to AMI and shall pay to AMI as liquidated damages and not as penalty the sum of $1 million, which the amount represents the result of the reasonable endeavor by AMI to ascertain the fair average compensation for any damages that AMI will sustain as the result of such disclosure. And the amount of those damages is impracticable to calculate or ascertain with certainty or specificity. Looks folded then printed. Yeah, I think this was pulled out of someone's pocket. Except as otherwise specifically amended herein, all the terms and conditions of the agreement are hereby ratified and confirmed. In the case of conflict between the agreement and this amendment, the terms and the conditions of the amendment shall control. Please sign below. So here we go. Mr. Dino is signing it here, and then the American Media Company is signing it here. So that is the agreement. So everybody, I think what I'm trying to show you here is we have 3 different people here. We have 3 different people, and we have 3 different agreements. So we have one agreement here involving the $130,000 that was split into legal expenses. But then we have this catch and dispose scheme with this Mr. Pecker dude who decided to pay $30,000 so this guy wouldn't talk about a love child, and pay this poor woman $150,000 kind of, with some career movement kind of that didn't really happen. So that was his agreement, because he was friends with Mr. Trump, because these two had this agreement that if anything bad came out, again, this was signed in 2015. She was also signed earlier as well. So what would have happened if these stories had come out at the time that these people wanted to say it? That's my question. He kept these stories under wraps and he paid them. What would have happened? I don't know. Maybe nothing. Maybe nothing. Stormy definitely had the better agreement. Well, she came later. Shows repetition of his behavior. So exactly right, everyone. Exactly right. Now, one of the things that was being contested was that the DA in New York had wanted to use the Art of the Deal and the Access Hollywood tape to show how Mr. Trump deals with these kinds of situations. How does he deal with women? How does he handle situations like this? They're saying, well, we have the Art of the Deal where he, tries to go after people that he thinks has gone after them. And then we have this where his respect for women is pretty low. Oh my gosh, thank you so much. Oh, that was adorable. We've got all of these things. We have this huge pattern of behavior. And we've got this guy who's a friend of Mr. Trump. We have this guy who's a bad attorney. We have this guy who came in, got her story, and held on to it, but called Mr. Trump. So he called Mr. Trump and said, hey, this woman's got a story on you. We're going to, put it at the bottom of the pile, but, what are we going to do about it? And then, so these two people are dealt with in that manner. And then we've got Miss Stormy Daniels coming in as well later on. Dino in the house. So we got a doorman, a Playboy model, and an adult film star. And we've got a magazine person. Now, if you told me a few years ago what's fake news, I would have said the National Enquirer. I mean, right? And so this fella, though, somehow is playing this pivotal role. I would say somebody had asked me who I thought the star witness was going to be. And if he tells the truth, it's going to be Mr. Pecker. Mr. Pecker is the person that's putting all of this together as far as the catch and get rid of scheme goes. It's going to be all on his shoulders. He's going to have to be shown to be reliable, or at least trustworthy enough that the information, so long as he's truthful, that he explains, he's going to set out the whole scheme. So he's basically the partner here, the partner in, business. So if you ever see the shows where they're like, oh, get your partner to flip on you, right? Where they always trick them and they're like, he's telling all of it. He's giving it all away. That's what this fella's going to need to do in order for this to be appropriate. So we've got Miss Westerhout as the secretary, who's going to be able to come in and talk to us about these checks. We've got Mr. McConney, who's going to be able to come in and tell us about one of the checks minimum, and as the ex-controller also knowing about this whole situation. We've got Mr. Weasel in here, was specifically to the check number 4 because he signed it. Is he going to be brought in? I don't know, but it's possible. And then we also have Miss Graff, who's his secretary in New York, who's going to be able to come in, and honestly, she's going to be able to talk about these general ledger entries. So we're going to have general ledger entries. She's going to be able to verify his signature on the check stubs, also on the checks that he wrote. So she's going to play a key role as well. And then we have Mr. Cohen. Reliability is going to be an issue, but on the other hand, they're his invoices. So we got a lot going on. Oh my gosh. Yes, general ledger entries. We love these because there's a date and there's a number for each one. We love that. So that's the counts that we're dealing with here. So we've got 34 counts. Every single count is going to need, has a document that goes with it. And that means it needs a witness. The witness has to testify in order to verify and authenticate whatever the document is, be it the invoice or the check. Oh, where did I put the checks, everybody? I don't know where the checks went. Oh, here, they're in the back. There. We've got to verify the checks, get that in front of the jury, and the jury needs to believe that it's authentic. All they have to do is look at the document. If they believe the document's okay, then they need to take two roads. What was the reason behind it? Was it the 2016 election? Was that the question that we're dealing with? We have a felony. If not, if it was just being dumb and just being bad faith and just doing stupid stuff, we may be down the road of a misdemeanor, but we still have bad statements that you're not supposed to write in business documents. So we still have crimes no matter what. We've got a lot of crimes, but what level of crime we will have to see. Accountability or accounting is black and white, no gray. Exactly. There's no gray. The only gray involved here is whether or not this was done in order to affect the 2016 election, everyone. The reason why they wrote out legal services was so that it wouldn't be discovered that Mr. Cohen had paid Miss Daniels all of this money. That's part of it, but it goes hand in hand again, though, with these two here who were paid to be quiet before Miss Daniels was even in the picture. Love your oh, thanks. Yeah, my exhibits. It helps, you know. It's hard to keep track of all this stuff. I can't keep track of it. It's 34 counts here, 32 counts in Florida, you know, 4 counts in DC. There's like 42 counts at Georgia. It's madness, everybody. Madness. Excuse is going to be he didn't want his wives to find out. Could be. And, you know, that could be. And if they can shift it, from this idea of not telling the public something because he didn't want it to affect the election to, well, I didn't want my wife to find out. You know, it's possible that that could bump it down to a misdemeanor. Again, lesser included offense is only going to be allowed if the judge allows it, if that instruction is given to the jury later. Right now, we're charged at felonies. We're not charged at misdemeanors, so it will depend on the jury instructions given. But usually, when you've got a felony at this level and you've got some questions about the actual reason why this was all done, then, you know, that lesser included offense is going to make more sense. But this is only a little piece, everybody. This is all what I could cobble together by what's online. This is not everything. The DA's got a ton of information that we just don't have, and much more concise information when it comes to like this catch and dispose of scheme. So this, again, if I can find this much information just online, just looking around, I can't even imagine the like boxes of evidence that they actually have for the trial. So it's going to be a lot. Do we know in general what the defense will be? Not at this point. Not at this point. You know, they've tried with their motion in limine to get everyone discredited, to get all the testimony tossed, and that didn't work. So usually the motion in limine gives you some idea of what their defenses are going to be. They tried to use the defense of reliance on counsel, but Judge Merchan was like, nope, you didn't plead it. They tried to use immunity, like, nope, you didn't plead it. I'm not even going to deal with it. So at this point, we just don't know. We don't know what it's going to be. Book were perfect. Never any better books. It was the most perfect book ever, Anthony. They're getting it from your lives. No, they're not. No. This is all based off of everybody. You have to understand, this is all coming from the grand jury indictment here. This is the indictment. This is where it's all coming from. So I may be showing you information that I was able to pull from lawsuits, but it's all here. It's all written out. Suppressing woman 1's account, suppressing woman 2's account, the AMI CEO, what he's doing, and actually a lot more stuff I didn't even cover is in here as well. But this falsifying the business records, all of this is all in the indictment. It's all here. It's all there. Yes, thank you all of the new subscribers. Oh my gosh, I'm very excited. So is there any other delay tactics he can do? Well, I mean, who knows? You can always try to set something on fire, I guess. But, legally, I think Merchan has shown over and over and over again, he's like, we're getting her done. This is done. We've got stuff to do. We're moving forward. And he's the one that also was involved in the prior case involving the company as well. So there was a criminal case also. He was involved in that. So it's like, this isn't his first rodeo. He's like, I've seen all this stuff before. We've been here before. We need to get it done. So I think he's doing a pretty good job. This judge isn't having it. Yeah, and I think he's doing a good job. But, I think part of it is also because he has been through this before. This has been years in the making, everyone. There have been... Mr. Trump has filed for recusals. He's filed lawsuits against Mr. Bragg. He's filed lawsuits against the judge. He's appealed everything to federal court. Federal courts kicked it back down. There have been defamation lawsuits. The Representative Jim Jordan fellow was involved in a defamation suit. I mean, this poor Mr. Bragg has been kicked around the world throughout the years trying to get this to court, trying to get it sorted out. So we are really at the point now where it's like you have literally tried everything you could possibly do, and we're done. We're done. We have to go forward. We have to go forward. Every delay tactic that could be done except directly going to the Supreme Court, the U.S. Supreme Court, and saying, please stop, I beg you. Which could, I guess, always happen. Who knows? We're kind of outside of the lines here with everything. But because this system works so slow and goes so meticulously, we can look back and say everything that could have been done was done. Every single thing was done in order for you to have due process. So whatever happens with a jury happens. If the jury comes back with not guilty, then there you go, not guilty. If the jury comes back with guilty, well, there you go. Like, that's how the system is supposed to work. But Judge Merchan had put all of this on hold back in November, picked it up again. He set it all down in November and said, we're not talking about any of this stuff until February. Picked it back up in February. When he picked it back up, we went forward from that point on. And from then on, the judge was like, look, we're going. So the omnibus order came out about mid-February. And here we are, mid-April, and that was it. So we had a short period of time from, he picked it up and he put it on the calendar and we were good to go. Thank you, Mel. Oh my gosh, of course. They're so ready to look for... Oh, I know. It's going to be very interesting, everybody. So here's kind of my plan, just to give you an overview. My plan is, for me, I'm going to be kind of watching for the reports for the people that are in the courtroom or in the spillover room. So I want to see actual writings and actual things from people there. Now, they're going to be writing stuff out as quick as possible and putting it online in whatever form that they can because the cameras aren't allowed there. There's no recording devices and those kinds of things. So what I plan to do is to be watching those as they come in. And then my goal is to do a Q&A and do a summary in the evening. I'll be back 7 o'clock Central Time and kind of go through and talk about what the reporting has been from the people in the courtroom. We can get reporting from all of the news stations. That's fine. But what I'm looking for are for people to actually have specific writings from what they're observing in the courtroom. So that will be my goal, and I plan to do that every night as long as this trial's going, as long as my voice holds out. So that's my goal. I will come on also in some various other parts and kind of go through and explain different terms and things as they come out, as it goes on. But really my primary goal is to kind of just do a recap every day to kind of sort through, because a lot of this is going to be shock and awe. Oh, it's the first president in a criminal case. It's like, yeah, that's fine, but what's actually happening? So my primary goal is to just say what's happening, who's actually reporting, who's in the room, all the commentary from all the news sources. That's just fine, but that's not me. That's not why I'm here. I'm just an attorney, and I just want to hear what happened. I want to hear how voir dire went. I want to hear how many people were like, there's no way I could possibly sit on this jury, and so the judge was like, you're free to go. That's what's interesting to me. So, we're not even going to be in a situation where we're in a strike for cause quite yet. I don't even think we're quite there, but that's something for me that I will be trying to register. Now, I've even got my little jury chart here, so we'll be able to kind of set out the numbers. We'll have no idea who these people are, but we'll be able to at least give them a place in the courtroom as we go through. So when we start getting into opening statements and we start getting into evidence, we'll be able to at least set out who our 12 jurors are, who our alternates are, as far as actually taking space. Numbers and those kinds of things, you know, of course, are very protected, but you know, this will be to the side, we'll have the jury to the side, and then we'll start going through the whole process. And also watching the objections. I think it'll be very interesting to see what objections get tossed out as we go through it as well, and how Judge Mershon's ruling on those objections as well. Thank you for doing that for, oh my gosh, of course, Karen. You know, I'd be doing it anyway. It's just nice to be able to share it with other people. So my family's like, who are you talking to? Like, just me? So it should be a lot of fun. I think it'll be interesting. Will the reports hear the questions too? To some degree. I think we've got, you know, we had a list, and I've already kind of gone through those jury questions, and I'll go through those again tomorrow night when I do the recap of what these potential jurors are being asked. So I'll go through those questions, and then that opening statement too that the judge will be given. But yeah, I think a lot of the information will be open and be able to be heard. But, you know, the judge will also have to be pretty discretionary on, you know, protecting the privacy of the jurors as well. To agree to be on a jury, they'll know the same day. They're going to have to whittle the number down. So it's going to be a process of elimination. So we're going to have several hundred, then we're going to eliminate it down to 75. And then out of those 75, we're going to pick, you know, another 25. And then out of those 25, we're going to find 12. So if you're in the batch of 75, you might get picked, but you might not. So it's going to kind of depend. It's this whole process of whittling it down and making the group smaller and smaller. So you may or may not know exactly where we're at. Very later, Finn, tell my family. Oh, of course. Of course. Will Trump be in the building? Oh, he has to be. He has to be. He is the criminal defendant. He has to be present. He has to, because we do not want any constitutional questions coming up. We do not want any Sixth Amendment questions. You want to have your due process. You want to have all of that going on. You have to be present in a criminal trial. So part of the criminal trial is voir dire. It may seem administrative. It may seem like, oh, well, you know, they're just cutting down the numbers before we can get to the true jury pool. It doesn't matter. It's still part of the whole process. And it's technically, trial does start tomorrow. And that means you have to be there. You have to be present and be there. Medical emergency, true, could be. Non-stop route. Well, yeah. Will they sequester the jury? Yeah, I believe so. But, you know, there's lots of forms of sequester. It's a continuum. There's all different ways you can sequester jurors. So the judge will have to find the least restrictive but most appropriate level of sequester for them. So a lot of people feel like sequester means you're just, you know, you're all in one room together for, you know, months and months. And that can be it, you know, but that's like the most extreme level. So the judge will have to figure out what will work best here. I don't doubt that there will be some sequestering, but again, what level of the sequester, I do not know. But if he causes disruption, the judge kicks him out, then he can go campaign. To some degree, although what the judge may do to kick him out is say you're not allowed to be in the courtroom, but you need to be in this room next to the courtroom. So you're not allowed to leave the courthouse. I would highly doubt it if the judge is like, all right, fine, be gone, be off with you. It would be more like, no, you need to just go to the basement. Go to the basement, sit in the room. Because the defendant has to be there. Because of your right to this public speedy trial, the defendant has to be present, because we cannot come back and say, he cannot come back and say, well, I wasn't even there that day when they did this, that, and the other. Like, well, you weren't there because you left the building. Like, we just can't even come back and deal with those on appeals. So they have to be there. The defendant just has to be present. There have been times where defendants haven't shown up, and, you know, in other kinds of cases, and there's been a bench warrant. And so you put a bench warrant out, you go get the defendant and pull him back in, put him in jail, let him sit there a couple of days, and then we go forward. Will he have a TV to view if set in another room? Possibly. I would say part of your right to confront is you have that right to confront your witnesses. And so you have that right to actually look at your witnesses. But your full trial, all of those things, you just want to make it so that the defendant has every opportunity to see every single thing about it. And one of the things, too, is the defendant has to be able to assist in their own defense. And that, again, means they need to be present to talk to their attorneys. Like, you can't just hand it to your attorney to just take it and run with it. Like, you actually have to be there so that if you want to involve yourself in your defense, you have that option. So that communication has to be protected as well. So we've got to just make sure that he has that opportunity. Yeah, it's going to be quite the show, everybody. It's going to be quite the show. It's going to be very interesting. Very interesting indeed. Will DePress be outside the courtroom so he can complain? Yeah, I mean, of course. He can go outside and complain all he wants. Unless the judge somehow adds something to the gag order that's already in place, the protective order, which I highly doubt. As long as he's within the confines of the protective order, he can say whatever he wants. He can go outside. Yes, the press. Yeah, he can go outside and, do his political rallies outside. He can do whatever he wants as long as, he's following the rules that everybody else has to follow when they're outside of the courthouse. And there is some decorum. There are some rules that have to be followed. But as long as he's within the confines of the gag order, he can go out and chit-chat all he wants. Truly a protection for the defendant to be strict on that. Absolutely. Absolutely it will be. Absolutely, I agree. Not looking forward to that. I know. He's already broke the order. True. But, again, there's all the questions of at what point do you call him out on it? And it sounds like the judge here had already said, well, there's a couple things you guys could have called him out on, but you didn't, and that's fine. I'll leave it up to you. Witnesses protected? Absolutely. Yes, the witnesses are protected. The jury's identity will be protected. The courthouse, all of that they've been working for a while now to make sure everything's in place so everyone can be safe. So DoorDash McDonald's, yes. 2 exciting events tomorrow. Oh, is it tax day tomorrow? Oh my gosh, everybody, tax day. No! Oh, I'm such a dork. I try to do taxes as soon as the year turns. So I'm like, what? Gotta take care of all of that. But yeah, it'll be very interesting. I would say just make sure don't get caught up too much in the reporting on the shock and awe. Don't feel like if anything is reported like, oh my gosh, this is crazy, or can you even believe it? Just doubt it. Just doubt it, because I'm not going to say the media is one way or the other, but I am going to say, their job is to catch your attention, and the bigger and brighter they can make something, they're going to catch your attention. So, before you feel like, oh shoot, we've got the whole thing's being tossed out, yikes, like just step back a minute and just take a minute and look, because they're definitely going to be in that mode tomorrow of everything is going to be shock and awe and everything's going to be crazy. So I would say just remember, yeah, the hype, exactly. Watch out for that, because that's easy to fall down and I fall down it too. I'll see something and I'm like, oh my gosh, what just happened? And then I go pull the document and I'm like, wait a minute, that's not what it says at all. Oh my gosh. Yes, well, there's bias, and of course you have to look to see what the motivation is. Like, why are they doing what they're doing? And there's lots of different reasons, and primarily a lot of it has to do with they got to pay their bills. So that's a big part of it. Do you think the judge will talk about Trump attacking Andrew Cohen this weekend? Oh, I don't know. Maybe. I think the judge is willing to let it lie unless the state brings it up at this point. Absolutely fall for it. I know, I do too. They're good at it. Well, of course, they really are. That's their job. They're very good at it. But, just remember there's an actual document out there that's going to clear it up. And once we get the document and we read the document, then we'll know what's actually going on. And that's kind of our safety net. So that's how we can tell, if it's hype, or if it's actually what's going on, is once we actually see the document. Why Ari thought interviewing Avenatti was a good idea. That's a good question, and it's kind of a sad story. The attorneys involved in these cases are awful. They're just awful. The attorney for Miss McDougal was awful. The attorney for Miss Daniels was awful. I mean, it's just awful. So I feel bad for them. Again, it really ruins our reputation. Own the media, make decisions in too many regular. Well, I mean, you're not wrong. You're not wrong. I mean, if you look and see who's running the world, I mean, it's not a large number of people. But I try not to think about that too much. Yikes! You're so awful. I know. It's so sad too, because if any of these women truly understood what these legal terms meant, and this drives me crazy, and I know it's my soapbox, everyone, but if they truly understood what the legal terms meant when she signed this contract, if she would have understood what everything meant, she really could have, been okay for herself. She could have made sure everything was all right and that she was safe and protected. And so it just breaks my heart when you pull an attorney in and they leave you in a situation where you have no idea what's going on, but yet you sign it anyway. It's heartbreaking. Yeah, absolutely. Absolutely. Yeah, there should be lots of art for tomorrow. So, well, with that, my friends, I'm going to need to sign off at this point. This was my second live for today. I'm happy to do it. My first one earlier today had to do with an interesting order Judge Merchan had. So that was a great one. I will be posting it on my Tube of You. And again, I will be back to do a recap in the evening, 7 o'clock Central, everybody. So if you've got questions, make sure to just put them on my post. I'm happy to help out wherever I can. So always wonderful to hang out with everyone. Thank you so much for coming by and visiting for my sub chat on Sundays. Hopefully I'll remember to turn my regular chat back on again tomorrow, everybody. Sometimes I forget. But do like to do my sub chat only on Sundays. The rest of my chats I always have open for everyone. So see you all tomorrow. Have a wonderful rest of your night, everyone. And take care. It'll be a very interesting day, everyone.